Hello, everyone. I'm Brian Hengesbaugh, partner with Baker McKenzie in Chicago, and I am chair of Global Privacy and Security for the firm. We're here to talk about the California Consumer Privacy Act and specifically how it's going to relate to human resources data. CCPA is a new type of law to the United States, comprehensive privacy legislation. If you're familiar with what the Europeans have with the General Data Protection Regulation, this is similar in terms of applying to any data about a person, specifically a California resident. And that's where we bring in, despite the name, California Consumer Privacy Act, consumer is defined as any resident in California. So it sweeps in employees, contractors, other workforce members, et cetera. So it's an issue that we're going to have to deal with in the human resources context. A few aspects of the law to bear in mind. One is there's 4 pillars to doing compliance with CCPA: notice, choice, access, and deletion. And in this series, we're going to do the next part 2, we're going to look at notice and choice, and then part 3, we're going to look at access and deletion. Some really critical issues to look at in terms of enforcement. There's 2 layers to enforcement. The first is the California Attorney General has enforcement authority over the entirety of the statute. We're expecting some regulations to come out from the Attorney General. The law is set to become operative on January 1, 2020. We expect that the California Attorney General will probably still be in the midst of issuing regulations and probably won't start actual enforcement at the Attorney General level until July 1, 2020. But another important dimension of enforcement is private right of action. So specifically targeted at data security breach, the plaintiff's bar will now get a private right of action with statutory damages of up to $750 per individual per incident. So you may know that they've had trouble actually proving damages in other types of data security incidents beyond credit monitoring costs and some other things. But this is a very hearty up to $750 per individual per incident private right of action, specifically targeted at security breach. We know and we expect, however, the plaintiffs' firms will probably try to press that even further and get broader private rights of action through unfair competition and other theories for broader parts of the statute. Another element to keep in mind is the changing regulatory landscape. So we may see changes to CCPA itself. In fact, even the California Attorney General is supporting a bill to expressly make a private right of action across the entirety of the statute, and other changes are being considered in California. Beyond that, there's the possibility of federal preemption of CCPA. There's active consideration on the Hill, both Senate and House side, looking at bills. You can't really count on the federal government saving you, though, with this one. I think there's enough differences in what people think ought to go into that bill that we may not ever get consensus on a federal preemption approach for it. And then also we have other states. We have Washington, New Jersey, and other states that are coming out with their own version of CCPA. So comprehensive privacy legislation applying in the human resources context is here. It's going to be with us now in the states, and we really need to get ready for it. So thank you.